class, we've been discussing about Crystallex versus Venezuela. In the earlier video, we discussed the factual circumstance of the case, and in this video, we'll discuss about the FET claim made by Crystallex, what were the arguments that it had advanced and what was the decision of the tribunal. So, in this case, in this particular argument of violation of FET, Crystallex relied on many inherent principles of FET, and it stated that Venezuela has violated the inherent elements of FET clause like legitimate expectations, denying investors legitimate expectations, then arbitrariness, violation of transparency, lack of consistency, lack of judicial propriety and due process, discrimination, abusive conduct and bad faith. So, it's Crystallex basically claimed that Venezuela has engaged in all these conduct and all of them are tenets of FET clause and this was violated. So, the tribunal initially looked at one by one. The first allegation that it looked at was whether Venezuela has violated the Crystallex legitimate expectations. And legitimate expectations, the tribunal also acknowledged that it is now rooted in arbitral practice and this concept is not new. It is also part of many countries' administrative law, including Venezuela's administrative law, wherein Venezuelan law provides for the concept of legitimate expectation in the dealings between the citizens and the public administration. And what would be the content of legitimate expectation? Then Crystallex stated that if at all it relied on any specific representation from the government and the government going back on that representation, then that amounts to frustration of investors' legitimate expectation. So, basically Crystallex said there were three moments in which legitimate expectations of Crystallex was sort of frustrated. The first legitimate expectation Crystallex said was at the time of making the investment, and the second one was at the time of receiving the letter from the Vice Minister, 16th May 2007 letter. Then since content of the letter stated that the permit will be handed over once a bond is paid. So, then Crystallex stated that this is something that amounted to legitimate expectation. And thirdly, when the permit was denied for 2008 to until the termination of MOC, at that point of time also apparently Crystallex had a legitimate expectation that the project will go on, and that was the third moment. But with regard to the first and third moment, the tribunal concluded that basically what Crystallex was expecting was that Venezuela will follow its own law. So, that is something that is general expectation and not a not expectation that arises out of a specific commitment. And therefore, the tribunal looked at the second moment that Crystallex stated that it had a legitimate expectation after it received the letter on 16th May 2007. Okay. So, here how did it go? So, on 16th May 2007 letter, if you look at it, the phrase, the language that was used was, once the bond is posted, the permit will be handed over. So, there was sort of a positive assertion as to the fact that the permit will be handed over, and the tribunal concluded, okay, so this sort of creates a legitimate expectation. But Venezuela was contending that the permit only the permit that was mentioned in that letter was only relating to the preliminary works and not for the entire project. And Crystallex stated that initially when they were applying CVG, and Crystallex was only applying for preliminary permit for preliminary works because they thought that would expedite the process, but later on they abandoned that track and then they started applying for permit for the entire project itself. So, then the tribunal had to decide the question whether the permit scope as mentioned in the 16th May 2007 letter, does it relate only to preliminary work or is it for the entire project. Then it looked at various documents and then it came to the conclusion it was actually relating to the entire project and not just for preliminary works. The second contention that Venezuela took with regard to the scope of the 16th May 2007 letter was, since the letter uses the phrase exploration, so that the scope of that letter is only limited to exploration phase. Then the tribunal had to see whether the permit, the letter, the scope of the letter, is it limited only to the exploration phase. Then on the preponderance of the evidence, it concluded that Crystallex had already completed the exploration stage, and why would it why would it ask for permission for exploration stage? Then the proposed permit that is mentioned on the 16th May 2007 letter would be related to the exploitation stage itself, and for this the tribunal relied on the existing documents. So, on the preponderance of the evidence, it had come to this conclusion. So, this was clarified with regard to the scope of 16th May 2007 letter, and the tribunal clearly held that there was violation of legitimate expectation. So, that was on the one hand. With regard to other elements, specifically with regard to arbitrariness, violation of transparency, inconsistency, and lack of judicial propriety and due process, then the tribunal looked at the permit denial letter and the termination of MOC. So, the permit denial letter contained assertions with regard to environmental sort of an environmental concern. So, then the tribunal questioned that in case if there is environmental concern, and if that was the case, then in the entire 4-year review process, these concerns were not raised before. Especially the tribunal had a problem with the mention of global warming in the permit denial letter. So, it said that if global warming and carbon emission and all of these were problem, then why was not mentioned in the 4-year review process? Why was it only mentioned in the permit denial letter? Also, the tribunal stated that EIS had thousands and thousands of pages. So, when the permit denial letter gave reasons for refusal of permit, it had a vague language and a general language, and it did not refer to any specific page of the EIS. By doing this, the tribunal felt that by not giving support data and by not using precise reason for not giving the permit, ARN permit, the Venezuela has robbed the opportunity that would have otherwise been given to Crystallex, either to remedy those adverse things, or at least to challenge the decision. So, no opportunity was given to Crystallex in the context of addressing certain grievances that Venezuela had, and it could have at least brought it at any point of time during the 4-year review process, but it only brought it at the time of denying the permit. So, that was problematic to the tribunal, and the tribunal felt that somewhere there is lack of transparency and arbitrariness and all of that. Moreover, there was one report that was submitted by Venezuela called Romero report, so it is a technical inspection report, which stated that the permit should not be given, and the date of that report was 8 months before 16th May 2007 letter, right. So, then Crystallex stated that even at the time of document disclosure right before the arbitration, this report never came to our attention. So, then Venezuela was relying on Romero's report also for saying that the permit had to be denied. So, now the tribunal questioned this. Basically, Crystallex stated that this is a fraudulent report. The tribunal questioned it, okay, if 8 months before 16th May 2007, if you are aware of existence of a report and you know that the permit will be denied, then through 16th May 2007 report letter, why would you ask Crystallex to pay a huge sum of money as the bond payment and environmental taxes? Why would that happen? There were many inconsistencies, and Venezuela was not in a position to give answer to these inconsistencies. The tribunal stated that without answering the question whether it is a fraudulent report or not, it said that even Romero report suffered from the same lacuna as that of the permit denial letter. So, it did not have support data, it did not give precise reasoning as to what should why the permit was denied and all of that. So, what we see here is the tribunal stated that there was inconsistency and there was arbitrariness and there was lack of transparency. So, that was all held. So, now with regard to other elements that Crystallex claimed as a violation of FET clause, that is with regard to discrimination, abusive conduct, bad faith. So, here the Crystallex relied on the fact that initially CVG was supposed to enter into a contract with the Russian company for exploitation of this, and with the Russian company, CVG and Russian company is supposed to establish Venris company and all of that. So, there was this one presentation called Venris presentation that had happened. Probably the president traveled to Belarus and there was a meeting and there was a presentation. So, apparently in that presentation, one of the strategy that was mentioned was to kick Crystallex out of the project, and the strategy the strategy was to how to kick Crystallex out of the project without paying any compensation. So, that apparently was there. So, then that was presented before the tribunal, and also finally the CVG entered into a contract with a Chinese company, CTIC. So, basically it was not able to conclusively prove that there was discrimination. Tribunal also stated that it was not unsympathetic to the discrimination faced by Crystallex, but then some sort of a conclusive evidence had to be placed, and also the Venris presentation could not be attributed to Venezuela. So, on these elements with regard to discrimination, bad faith and abusive conduct, Crystallex could not make a successful claim, but otherwise the tribunal had found a violation of FET clause, especially with regard to legitimate expectation that was frustrated, that was created based on the 16th May 2007 letter, and it also found that there was inconsistency, arbitrariness and lack of transparency with regard to permit denial letter as well as the termination of MOC. So, and for MOC, the tribunal felt that it looked at the internal documents of CVG to come to the conclusion that probably the termination of MOC was a result of the political pressure, the political statements that were being made at the highest level of Venezuelan authorities that impacted the permitting process, because otherwise there was nothing on record to show that there was contractual violations on the part of Crystallex. In fact, when Crystallex had written to CVG asking about what is the nature of the MOC that they had signed, and CVG had replied that it is very much in force, and since it was signed for 20 years. So, the termination of MOC itself was, there was no it was arbitrary and lack of transparency and lack of due process. That is how the tribunal concluded that there was a violation of FET provision of Canada-Venezuela BIT by Venezuela in this particular case. Then in the next video, we will look at what was the decision of the tribunal with regard to other two claims made by Crystallex, that is violation of FPS clause, full protection and security, and violation of expropriation clause. Thank you.